Welcome to the Challa Law Weekly Webinar, and this is May 11th, 2022. And nothing really major to report this week. And as a result, what we're going to do is to make sure that these webinars are more fruitful. We are going to start live. We're going to go to twice a month for our webinars starting June 1st. So that'll be June 1st, a Wednesday, same time. Unless you all email us and tell us there's a better time. And then we're going to have a town hall meeting once a month. And so we will let you know when the town hall meeting is, where we'll open it up for questions and so people can inquire about their case. Let's get folks a few minutes to get started, and then we can go ahead and get going with the Q&A. One thing I do want to report is that the USCIS now has a new plugin where you can input your receipt date, and they will tell you the first day that you can make a case inquiry. So that's kind of interesting. And probably by June, we'll have some interesting numbers, not only the June dates, but also, probably by then we should have at least the second quarter numbers and some of the third quarter data that we can share. And we're going to, just to make it more worth your time, what we're going to do is have you email us the questions ahead of time so that we can make sure that we don't have duplicates, because sometimes we run out of time and we're not able to answer everyone's questions. So this way it ensures that, we can group together the questions and make sure that everyone gets a chance to get their questions answered. So now I would like to ask Mr. Shekhar Challa to join us and start taking the Q&A.
Hello, good afternoon, Lakshmi, and good afternoon, everybody. It's a hot Wednesday night here in Chennai, but it rains, so there's 10 degrees less. It's still 90 degrees, so but I'm enjoying.
It is beautiful here in Richmond, and I think it's going to be nice for this week, but it'll be back to being 80 degrees and sultry by the time you get here.
All right.
Oh, you don't miss Chennai, right?
Yeah. Yeah, I see my friend, Mr. Daniel Robinson from Durham, North Carolina, is online for the first time in about a month or so after all his travel. And thank you for your support to Sunrisers, Mr. Robinson. Hopefully there'll be some magic this Saturday.
Glad you could join. I started watching this Netflix, not Netflix, I think it's HBO Max new series, and it takes place in Durham, North Carolina. But it's kind of very interesting. It's about a murder. So
Durham, North Carolina. All right.
But it takes place in Durham, yes.
Okay. So after that little bit of hanging around, fooling around, let's look at the first question from chat. I filed an I-765 H4 EAD application for myself and obtained the receipt notice before my current H4 EAD expires on May 26, 2022. I have also received the approval for my H4 extending the I-94 till May 26, 2025, making me eligible to work for next 540 days. We filed an advance parole based on pending I-145 AOS application as a dependent of my spouse last March. Once approved later this year, can I travel overseas, return back to US using AP in case I don't receive an EAD along with AP, and resume working based on the pending? Man, this is a long question. I'm going to stop here. and then I'll read the rest. I think, I'm sorry to say, but I think you should send your questions in bullet points if you have such a long question. Because first of all, you need to capture the attention of the attorney, right? You want a good answer from your attorney, you got to have very clear, concise questions in a bullet form. Then what I will do is I'm going to look at the 5 bullet point and say, hey, Lakshmi, there are 5 sub questions. I'm going to read one at a time so she can focus one bullet at a time. I'm reading a paragraph. I'm sorry. Go ahead.
Oh, but I got it.
Okay.
Yes, you can. So, H4 spouses are a little, as I said before, a little different than H1Bs. So because the classification is not dependent on their own work, it's dependent on the work of their spouse. So as long as the spouse is maintaining H1B status, the H4 can travel on their AP, they can work on their H4 EAD, or they can work on their adjustment EAD, either one. It does not impact the H4 status.
All right. So should I have to read the rest of the question, or you already?
No, I got it.
Okay, good. Daniel Robinson says, good old Michael Peterson.
That's what the story is about.
Okay. Okay. Question from the chat. Oh no, is it? Authorized to. We have a new hire starting who's a non-resident but is authorized to work in the US. She provided 2 different employment authorization forms. However, they were issued on different days and have different expiration dates and different category codes. Question 1, do you know which one takes precedent and which expiration date I need to go with for verifying employment authorization?
Right.
For
so for just to give a slight overview, every employer is required to complete an I-9 for their employees, regardless of their immigration status. So that goes for US citizens as well as your international resources. The I-9 regulations were brought about during the Clinton administration during IRA. And it was to ensure, because IRA provided a lot of benefits to H-1Bs and green card holders. That was the year that was the legislation that actually increased the quota. And so what they wanted to do is make sure that employers had a mechanism in which they could, check that they were hiring individuals with a work authorized status. So they created this I-9 form, which on the face of the form seems very simple. But when you're completing the I-9 process, you're walking a tightrope. On one side, there are things you cannot do as an employer because you could be subject to national origin discrimination. On the other hand, you've got to make sure that you complete the process so that you are defensible in case there's any issues, ensuring that you have checked the work authorized status of each of your employees. There are very set parameters to that in terms of the days that it should be completed. But the most significant thing is the employer, number one, can only initiate this process after there has been an offer of employment and an acceptance, number one, because otherwise you could be pre-screening your applicants and be subject to national origin discrimination. So offer and acceptance for the job. Second, the employer cannot ask for specific documents. Now, there is the form itself, and then there is the documents that are associated with that form. So when the employee completes the form, they fill out what their current status is and what the expiration is. And so that should give you an indication as to what the matching form should be. Now, the forms presented to the employee are 3 categories. One is a work authorized and identity status documents. They are listed. Then you have 2 other columns, one for identity and one for work authorization. If the employee does not have a list A document, then they have to present both a list B and a list C document. So for employment authorization documents for an EAD, there is a number associated with that document that tells you under what classification the person secured the employment authorization document. So the person that you have hired probably is an H4 and also an adjustee. So depending on how they filled out their form, did they say they're an adjustee or did they say they're an H4? What I would do is give back the employment authorization document to the employee and say, hey, you filled out this form saying that you are X. So you need to ensure that the documents that you presented to me are consistent with what you presented on the form, and have them give you the EAD that needs to be activated. Now they can use either, but you can't choose which EAD to use. They have to present it to you.
Well, he's got two IDs listed there. One is category code C31. The other one is category code C09P.
Yes, I'm pretty sure that I've got to look it up. You can Google it, but I'm pretty sure that's probably an H4 and an adjustment of status.
Okay, his second question, his or her, I don't know, but I'm sorry. Is there any sponsorship or anything else we are responsible for?
Not if somebody's got a valid employment authorization document, no.
All right, let's go to the question from the box. From an anonymous attendee, I was told that interfiling is not allowed if downgrade is filed as an amendment since it is a successor of interest. So does it mean I got stuck in EB3 line and get GC only when PD becomes current in EB3?
Yes, because what happens is let me answer two different questions. So what happens with any type of amendment, when you amend your I-140 and you choose a new category or you retain your previous category, i.e. EB2 or EB3, either one. If you choose a new category, let's say you went from EB2 to EB3 and you amend, your EB2 no longer exists. You've amended it. Okay. So there you can't interfile using that previous I-140. You can, however, refile using a new I-140 once your successor in interest EB3 is approved. So that is something you can think about doing in the future, and I would do it if your amended petition has been pending for at least 6 months. Try premium processing it. Remember, you can't premium process at the time of filing because the USCIS has to request the original perm from the DOL. So because they have to request the previous perm from the DOL, that can take some time. Once they have that, you're eligible to premium process. Now we've seen it around 6 to 7 months. They usually takes them USCIS to obtain the previously approved original perm from DOL. So you can start, and even if it gets rejected for premium processing, that does not harm you in any way. So there's no problem in at least trying to upgrade it. And once it becomes approved, what I would suggest, instead of interfiling, I would go ahead and file a new I-140 485, for the new process. And again, you're going to have to request the the USCIS to request the original perm from DOL. So it's going to take some time, but that way, you've got the two processes in place.
All right, next question. I have a valid I-94 until 12/24. My current project is ended and I got a new project, but the issue is that the new project is only for 9 months. So H-1B amendment is filed. My question is, does it override my current I-94 validity from 12/24 to next 9 months based on the project?
Well, it depends on what your attorney did to present the case. What we always do, so there's a couple of things here. Number one, during the Trump administration, they had issued a memo that asked for, when you're on a third-party site, itineraries, contracts, and the like. That memo was since revoked by the current administration, Biden administration, so it no longer applies. So then you go back to the original requirements of the H-1B. And the original requirements are that you have to show sufficiency of work. And that work has to be projected. It can't be speculative. What's the difference between the two? A speculative proposed work is where you have really no basis. That's how I would put it. You're just speculating, not based on any facts. Projected, you're basing your what the work would be based on some type of factual data that you have. So what we like to do is present information about, most employers, when most end clients will not issue a work order greater than, 9 months is larger. Most of the time we see it for 6 months. But if you can show that that employer, that contract has been in place for a long time, and they continue to extend it, you can show that you've got sufficiency of work based on valid projections, which are based on historical data. If the client, for example, has other projects, you can show, if you're not on this project, you'll be able to get on other projects. So if your attorney presented it that way, then it should not be limited to the 9 months. And there's actually a federal court case that is on point for the federal district court case that is on point on this issue.
All right. This question is from the chat from Mr. Raju. He says, "Hi, sir. We both, my spouse and myself, don't have a valid visa. So can we travel to Mexico to extend I-94 with valid spouse H-1B approval? Can we both travel to Mexico?"
Okay, so you've got a valid stay, your visa's expired. Sure. Once you get an appointment in Mexico, and if you email us at info@challalaw.com, we'll give you a contact that actually helps facilitate processing out of Mexico.
That's about it right now.
Great.
If anybody has any other questions or we have any new information to share?
No, we just are, for all the people that are in queue and waiting on the lines, we've just started filing our, adjustment of status for some of the folks that were that had previously filed an EB-5 petition. And both of them are on student visas. So what's great for them is they'll be able to, avail themselves of the adjustment process. They can't leave the country without their advanced parole, and they've been informed of that. But what's great is they don't have to wait in the 12-year queue to get their green card. So if you know of anyone who does not, we don't see a change coming up for, how the visa allocation, immigrant visa allocation is currently in place. And I don't see with this highly polarized political environment that we're going to get anything done out of this particular Congress. So if they have the 800,000 and they can, remember, you can get it from multiple sources, multiple people, multiple countries. It does not have to be one single source. And we can help you with that. Then that's a great way to ensure that you're not in this 12-year line.
Yeah, I'm here in Chennai, India for another week. So if anybody, your friends, relatives, well-wishers, neighbors, interested in EB-5, connect me to them or vice versa. I'll be glad to talk to them. Here's another question from Ritesh Kumar. I think we answered a question earlier. Thanks for your suggestion that I can refile I-485 in EB2 under Chart B, even if my wife entered US on parole status. Few attorneys were of the view that one has to be in non-immigration status to do that. Please guide on the benefit of refiling I-485 instead of interfile.
Number one, just because as long as your wife, as long as you're on a valid H-1B, the mere fact that your wife enters as an H-4 on advanced parole does not change her status to an adjustee. The regulations are very clear. H-1B is dual intent. And there are memos that clearly outline, USCIS memos that clearly outline that the only time that your status would change is if the H-1B employee works for an employer other than their H-1B employer. Then you are no longer an H-1B status, and you were then an adjustee. But as long as that does not happen, it does not matter whether you travel on your H-1B visa or you travel on your H-4, whether you're the H-1B or H-4. That doesn't negate your H-1B or H-4 status, number one. Number two, the reason why I am saying file a new I-140, as you know, now the USCIS is fast tracking or trying to, for certain I-140, 45 filings, 45 filings, once the I-140 is approved, they're sending it directly to the NBC. And so that we think right now, we don't know because NBC has not issued their processing times, but we think that should be a faster track. Certainly, because if you go to Texas, it's in this black hole of years and years of processing. So that's the reason why I, changed my previous suggestion just to interfile, because of the, opportunity that the case can get fast tracked to NBC.
All right, Mr. Raju, there is a link on the chat for the visa stamping in Mexico. If you want to grab that link, and you can refer our office, and I think you'll be taken care of. So the next question, again for the box, follow-up from last time. Are you seeing refile EB2 cases being moved back to TSC from MSC if EB3 downgrade I-140 is pending? Is that a trend you're noticing with your refile EB2 straight cases and EB3 I-140 is pending at SRC?
We haven't had any of those cases to be sent back. If you have any information on that, and Ashley, maybe that's something to ask the Telegram group, then let's see what's happening with other cases, but we haven't seen that in our office. Is Shaker disconnected?
Yeah, I'm here. I just wanted to lighten up the environment with some air.
Oh.
All right, Ritesh Kumar says, thank you for your response. Appreciate it. And looks like that's all for now.
Okay, guys. Well, thank you so much for joining us today. Those who have come every time, and those who are joining anew, and Mr. Robinson, it's always great to have you join our webinar. We will be back June 1st. That's a Wednesday at 12 p.m. Eastern Standard Time. We'll be sending out some information between now and then on what topics. And like I said, if you've got a topic you'd like us to cover, please let us know what those topics are. If you have another time that you think would work, we are hoping to do the town hall town hall broadcasts through Instagram on Sundays, Sunday late afternoon. Yes, sir.
As you leave, there's a last question if you can take. Can you refile an EB2 straight if EB3 downgrade I-140 is pending, does pending of one I-140 affect the other 485 straight case? Is there a different name for a straight case?
Yeah, I think he's saying a non-concurrent case. I think, I don't know. You know, I think you will have to wait till the I-140 is approved. You can, when you file concurrently together, you're able to, but let me think about it. There may be a way in which you can do this while it's pending. Email us at info@challalaw.com so I can connect with you directly and advise you on this.
All right. Mr. Robinson, I'll see you Saturday afternoon on the air
Oh,
for
your
cheering
team-
Sunrisers.
is this the final?
No, they have to win to be in contention for a playoff. So it's very important. But all of you out there, please support Sunrisers.
I think that's a little extreme to expect all these folks to
I'm
support
sorry.
Sunrisers.
I'm just trying to lighten up on Wednesday afternoon. So
Right.
there's somebody from DC to chase down right now. That's right. We don't want DC to win, because if DC win, then they'll have 2 points extra more than Sunrisers. I don't want DC to win.
DC, that's the Delhi Chargers? No,
Delhi Capitals.
Capitals. Ah. All right, then. With that,
Okay,
I want to,
that's enough cricket for now.
yes, I want to thank all my team for all their help. I want to thank you, Shekhar Challa, for
Thank you.
staying up and moderating this in your very hot climate. We look forward to, he will be back with us in Richmond, Virginia on June 1st. And till then, you all stay safe. And oh my gosh, Daniel, you have become.
Daniel, thank you, Daniel. Your analysis is too much.
Yeah, and it's amazing how much of a cricket enthusiast you have become. Indeed, Shekhar's cricket enthusiasm is contagious, because I get excited when he's here and when he's not here, even when he's not here, to watch cricket, just because, and I think Ashley wants to watch some cricket. So hopefully there'll be a game when you
Hey,
get
mark
back.
the calendar for July 7th. Cricket night at the Diamond. Thursday night, July 7th, fireworks right here.
Is
here
it
in
7th or
Richmond,
9th?
Virginia.
Is it 7th or 9th?
Thursday, I don't know, whatever that date is. I think it's 7th, but if it is 9th, it is 9th, but it's the first Thursday. The fireworks night in Richmond, Virginia. Come with family, friends, neighbors,
It's the 7th.
even your enemies. Have them come and watch cricket and baseball together.
Yeah, it was a lot of fun last time. We had a great time.
Yeah.
So anybody want any information on the Richmond baseball cricket night, please email us at info@challalaw.com and we'll send you that information.